Well, I think I'd like to change my approach. And I think the approach is to provide the viewer or the listener to understand the inner workings of what I see or what my office sees when people call in. So, for example, if a client calls the office, they're going to say, hey, we want to set a meeting with the attorney, the basic information. And you say, what's going on? Well, the question they have in their mind is, we need to do a probate. Our family member passed. Or we need to administer our trust. But how many times do they really know what they're talking about? They might say that we need to do a probate. Then I meet with them and they give me a copy of the trust. There's no probate if there's a trust. That's called a trust administration, right? Mm-hmm. Or they might call in and say, hey, we have a living trust. No, you don't. You got a will. And that's a little different. So I think what I'm starting to see is that, well, of course, if we take a step back and we see what's motivating all this is these values of real estate, and people seeing that high values of real estate and they want to sell, they want to make the money on the properties.
Right.
So the first thing is a family member comes in and says, our family member passed away, and we're all the beneficiaries are waiting for that piece of the real estate to come their way. But what do? They went to list their property, and the realtor said, you need to see an attorney. And that was the best part right there, that the realtor advised them to see an attorney. The realtor didn't give them the advice, which is the important part here.
Right.
Right. So,
or they waited to the last minute and they had a sale.
Right, exactly. And that does happen. And that's when escrow calls and everybody freaks out and says, what happened? Are we going to lose the sale? Now, in a market like this, and
in any market.
In any market, but in this particular market, I think that buyers are a little forgiving. Would you agree? Because they want the property. Mm-hmm. But in a general market, you could lose the buyer if too many hurdles come in the way of the sale. So, we get a variety of problems that happen before this sale is about to close. And it's usually because there needs to be a probate or there needs to be administration of a trust. And there's different situations that happens. Last week, to kind of throw a little change into the mix, is the client comes in and says her dad was entitled to the property, but dad died. And guess what? Dad didn't pay the mortgage. Okay? But it wasn't dad who was supposed to pay the mortgage, it was the daughter. The daughter didn't have the credit to get a loan for her house, so she used dad's credit. Dad got the loan. Dad was entitled to the property, but the daughter continued to pay the mortgage payments. Dad died. She hadn't paid the mortgage in 2 years. There's a foreclosure set 2 weeks later. Now, there's no will, there's no trust, and anybody who goes online or has experience with it knows a probate isn't going to be done in a few months or 2 weeks for that matter.
Okay, now let's explain what probate is for the listeners.
So the probate is, well, I was getting into it. It takes a year to complete it, right? And the problems with the probate is not only does it take forever, but its costs. So if we take a step back and we talk about what exactly a probate is, a probate's when, and actually I'm going to read it off my notes over here because I think I articulated it pretty clear. The function of its estate administration, it's administering the estate. The first step is where they collect and manage all assets subject to the probate. So for example, if someone passes, they have assets. They may have assets. They could have a house, they could have a car, they'll have bank accounts, they could have art, they could have wine, they could have anything. And that's where you take the time and you collect and manage it. Kind of like an inventory to know exactly what's part of the estate. Then you give notice to everybody's involved. Interested parties, other beneficiaries, creditors that you know about that may have an interest in those assets. Okay? And then you liquidate or you start paying claims or paying taxes, pay people who owed money, and then you distribute to the beneficiaries or whoever is entitled to distribution.
That would be the grandchildren, the cousins, siblings.
Exactly. And this happens when the deceased does not plan for their death. So there's no will, there's no trust, there's nothing. That's a probate.
That's when dad thought he was going to live forever.
Right. Now, he could also have a probate if he has a will. Okay, but the only thing the will is going to do is it's going to dictate on who the benefits from it.
That's right, because the firstborn son gets his motorcycles, and his daughter gets the boats.
Right,
and
so
forth.
exactly. So that's where the will would come in.
Yes.
Now, that doesn't take you away from a probate. You still probate the will. So with or without a will, you're going to probate. Okay? The whole process will save you a little bit of money because you have a will, and the will kind of dictate who gets what, versus going by what the state legislator intended and going without a will.
Now, if you can explain the probate, that's handled at the county courthouse?
So the probate, what happens is we file a notice of probate, and these documents are filed with the court. Okay, it's the Superior Court, probate department. And the judge calls you in, and he says, what's happening? I say, Your Honor, my client wants to have the letters of administration. She wants to be the responsible person of this probate. And the judge is going to say, well, okay, does anybody have an issue with this? Anybody have a problem with this? And my client will say, well, no, I have a waiver from everybody saying it's okay, I do this. Mm-hmm. Then the judge signs an order giving them the power to administer the estate. Now, I'm making it very, very simple.
Sure.
But I think I'm trying to be clearer than Google.com or Dr. Yahoo.
Right.
But, I'm trying to make it a little easier to understand.
Right.
But that's the process, and you do that in the Superior Court. Okay. So once that happens, once that person gets the power to manage the estate, then they can start dealing with all the assets and taxes and everything involved in notifying the correct parties and the creditors of that estate.
So let's say that's out of 5 kids, that particular daughter is child number 3,
mm-hmm.
and she lives closest to the property.
Mm-hmm.
Everybody else is out of state.
Right.
And she's going to be the administrator.
Right.
Of the probate.
Correct.
Okay.
But that's if the other siblings are okay with it.
Okay.
Right. So, and she gets that job to do it. Okay. Now, what people who don't pre-plan their passing, when they don't think about the future, the problem is the probate just takes so long. Okay. It could take a year. It could take longer. And there's a lot more interaction with the courts, a lot more interaction with your attorney. And attorneys get paid quite a bit. I mean, I'm nobody to judge, but they get paid because of the fact that there's a sliding scale of what the attorney's fees are going to be. And along with the costs associated with it and the time, a probate is a very, very long process and a stressful process. Mm-hmm. Okay, so that's the reason you're going to find if you do research that a lot of attorneys advise an individual to have a living trust created.
Okay, on that point, because it's my understanding a lot of older adults do not want to spend $2,000, $3,000, $4,000 on the paperwork
mm-hmm.
to handle a trust. But
Correct.
if it goes to probate, it could be $10,000, $20,000, or $30,000
Correct.
out of the estate.
Right, correct. And also, I think the benefit of the trust, beyond the cost benefit, is more control on who gets what. So, for example, let's say my client comes in and she says she wants to get a living trust. Okay, and we say, okay, well, let us ask you a few questions. Do you have someone you trust in mind to take care of your estate if something were to happen to you? And she'll say, yes, this person. And then we ask her, well, do you know what you want to do with your estate if something happens to you? She'll say, yes, I'd like property A to go to this son, property B to go to this daughter, property C to go to this kid. Okay. Now, she's already given a roadmap of what she wants done. When she passes, the person she trusts, the trustee, will come in to see an attorney, and the attorney will follow the roadmap. And that's called the administration of the trust. Mm-hmm. Okay. So, agreed, it's quite a lump sum to pay up front for a living trust. But in the end of the day, the client is doing it for the benefit of their beneficiaries, really.
Now, the probate, for the listeners, that's a process where we go through the county courthouse.
The courthouse, correct.
But if they have a trust, do they still have to go to the county courthouse?
So if you have a trust, you don't. Everything is handled through the attorney. There are times they will have to go to court, and that's going to come up if there's hiccups in the in the title of the properties,
I see.
or if beneficiaries disagree with distribution.
Sure.
So, for example, in my same trust example where the client came in and had the 3 kids, property A, B, and C, let's say down the line, 2 other kids think the kid that was appointed the trustee is doing a terrible job, or is taking money, or hiding, or doing whatever, then those kids might want to go to court over that. So if we take a step back and think a big picture, which I'll draw on our board, there could be court anywhere, but the trust administration is going to have a less court involvement unless there's a dispute.
I see.
Okay, so client comes in. If they want to do a probate, if there's someone deceased and they have to do a probate, we file the paperwork with the court right away. If there's a trust, client comes in, wants to administer that trust, we don't immediately go to the court. We just start administering the trust.
You just wait if there's a problem, then we go to court.
Yes, if there's a problem. And in most cases, if there's bigger families, I see bigger problems.
Yeah.
So it's a pretty standard procedure. I think that, I personally find probate and trust very interesting. A probate it's an administrative process. And in both cases, whether it's a probate or trust, you're gathering assets, you're paying people off the creditors to be paid, and you're distributing. And it all has to follow under this underlying understanding called fairness, right? I mean, if somebody's doing something unfair, the other party is going to get upset, right? For example, in the probate, if you're a creditor and you're owed money, then you're going to say, hey, you got to pay me. But if the representative of the deceased says, I'm not going to pay you, there's a problem. There's a dispute in the probate, and that could end up in a lawsuit within the probate. Or let's say in the administration of a trust, if one beneficiary feels that the other beneficiary is getting more money, there's a problem. That might be a court issue. So a lot of these things can come up, but if you go down to the basics of a probate versus a trust, the trust is a private document, less court involvement, a roadmap, and you get to decide who gets what. As a deceased, you get to decide who gets what within that trust.
Okay.
Now, a will does the same thing. You get to decide, but you're dealing with probate, costs and time.
Now, with the will, it's my understanding attorneys often tell older adults, perhaps you might want to explain to your children how you plan to disperse your assets after you're gone, rather than have them surprised.
That's correct.
Is that a...
That's something I advise my clients. And what I usually do is if a client comes in and we complete some kind of document, I immediately scan it into my computer. I give them 3 copies, the 1 copy to put in their fire safe or wherever they keep their stuff, 1 copy to their trustee or representative, and an extra copy for themselves. And it's not always so clear cut, because sometimes they don't want to tell that other beneficiary is not getting anything. Or they don't want to tell the other kid, look, you kind of weren't really the best kid around, so we don't want to give you anything.
Right.
So you just tell them, the kid who's going to manage it, what's going to happen.
I see.
But that trustee or that representative needs to know what's going on.
Okay.
And it's just it's a long process, because it's all it's really the individual taking the time, the person getting their trust completed, taking the time to think about what's important to them and who's important to them. And at times it's a couple thinking, we had 3 kids, but kid A was the only one that really understood anything. Kid B and C didn't really do anything right. Or kid C was, he's not going to be around, so they have to think about who they want to give that responsibility to,
Right.
without causing drama with the other kids.
Yeah. And there is a lot of drama.
There's always drama.
With this family here.
That's what attorneys get paid for.
Okay, so we are going to have the floor manager set up our tripod,
Okay.
and we will have camera number 1 do the illustration, film the illustration here. The difference between probate and trust.
Okay. So, I think you tell me what each is, right?
Okay.
Okay. So, I'm going to give you a few basics to take, well, the viewers to take with them when they go meet their attorney or they do their research on the benefits, okay? And I don't think I have the space to write it down, but I will go into basic examples. Okay. So for a trust, most situations are a couple comes in and they want to pre-plan. They're going to say, hey, you know what? We have worked all our lives, we've acquired all these properties or assets, and we have 4 kids, and we want to make sure they're each taken care of, okay? And we don't want them to have to go through complications with the court or any issues after. So they come in, meet the attorney gives them a questionnaire, okay? The questionnaire is going to ask them all the information about the assets, who's going to be their trustee. Their trustee is the person who's going to manage the estate or after the death of the settlors. The settlors are the creators of the trust.
So as an example, that would be the 3rd child out of 5 kids.
3rd child out of 5 kids. It could be child 4 and 5. They could be co-trustees.
That's true. Yeah, I've had that happen.
So you can have that also. So step 1, who do the settlors, the creators of the trust? And that could be child 4, 5, 1, 2, whoever. It could be none of the children. It could be the neighbor Bob. Either one.
Okay.
That's the trustee. Now, who are the beneficiaries? Out of 5 children, it could be 4 and 1 doesn't get anything.
And or that 5th, it could be that 5th child's adult son. Sometimes they do that.
It could be.
Okay.
It could be.
So we get the picture.
You get the picture. That's the trustees. Then you go to the assets. Now, here's the big important part of a trust. The assets, when you're living, need to be put into the trust. So, for example, if Scooby-Doo had a trust, he would be Scooby-Doo trustee, because while you're living, the settlor, the creator of the trust, is also its own trustee of the trust. So if Scooby-Doo is a trustee, it's going to be Scooby-Doo trustee of the 2018 Doo Trust. So that would be the title. Now, if Scooby-Doo has property, that property, a grant deed is going to be created. It's going to go from Scooby-Doo individually granted to Scooby-Doo trustee. Okay, and that has to be done.
Right.
Now, problem. Always happens. You must have seen it millions of times. Scooby-Doo goes and gets a refinance of his house. Okay? The lender tells him, we cannot refinance a house that's in a trust. Takes the house out of the trust, and does the refi. Forgets to put the house back into the trust. Then Scooby-Doo dies.
Happens all the time.
Okay, what happens then? Then the kids are going to say, we want to sell this house, but we have our dad, Scooby, had a trust. Escrow says, no, we're not going to sell it because the property was never put back into the trust. What happens at this point? If the property isn't in a trust, where does it go? It goes to probate. Or we go to court. And we come back to court and we say, Your Honor, the intention of Scooby-Doo was to have that property in the trust. Can we do that, please? And if nobody objects to it, the judge reads the trust, says, okay, that property goes back into the trust, and once it's sold, is distributed via the wishes of Scooby-Doo to the trust.
Okay.
That make sense?
Sure.
Okay, so that's a big part of the trust, is putting the property in there, or funding the trust, as they say. Now, that could be your cars, it could be your house, it could be your bank accounts, everything goes into that trust. Once the settlor or the creator of the trust passes, the trustee takes over for the benefit of the beneficiaries, which includes obtaining rental income, distributing to the beneficiaries, selling properties, managing, whatever it may be.
That is the successor trustee.
That's the successor trustee. Yes, you have the main trustee, settlor, then successor trustee, or co-trustee, or whatever.
And in the trust could be the Winnebago, the boats, the motorcycles,
anything you want.
And the house, and a rental property in Florida.
Yeah.
There you go.
Do it all in there. It's a good way to start. So that's the trust. But again, the key to understand what a trust is it's called a roadmap. You're creating a roadmap for the benefit of your beneficiaries. Okay.
Now, at this point in time, that could be $2,000, $3,000, $4,000 of paperwork to create that.
So you don't just get a trust. What happens is you're getting an estate plan.
Estate planning, correct.
And generally with an estate plan, it's like a binder and you get all this stuff. You get a bunch of documents in there. The core document is your revocable living trust, What that means is while the person's living, he can revoke that trust. But the living trust is the core document. Then you have something called a pour over will. And what that does, it pours everything into the trust that we haven't adequately described, maybe personal property, because you don't need to list everything.
Right, the Winnebago, the Harley Davidson.
Exactly. Yeah. So that goes into the trust. Then you have a financial power of attorney, which can kick in once something happens, and you have a healthcare directive.
Correct.
So, I mean, in my office, we usually don't create healthcare directives. I usually get the standard form because I feel nurses have an easier time reading a standard form than some wordy attorney drafted directive, like what's going on here, right? So we have that in there. And then we have something called a certificate of trust. Now, this is important because people don't know what this is. One of the benefits of a trust is it's a private document. You don't got to give it to anybody. You give it to your trustee, you give it to your kids, whoever you want, but you're not required to give it. So if somebody down the line, like a bank institution or maybe in a lawsuit, requires settlement, whatever it is, if they want a copy of your trust, you don't need to give them that. You can give them something called a certificate of trust. And what that is a 2-page summary. It lists beneficiaries, trustees, whatever it is, it's enough to answer the questions that somebody may have regarding that trust.
I see.
So you want to have that thing handy within your binder. So that would be your estate plan. And yeah, I think it varies with different attorneys. It varies in different levels or income assets, things like that. 2,000 to 4,000 starting, I would think.
Okay, and that estate plan, it typically have multiple copies. One you're supposed to put in a safe deposit box at a bank, one in a fireproof safe at home, and a third copy to.
Yeah, you know, with the original estate plan, I would put in a fire safe, give a copy to your trustee. If you're with technology these days, everything can be scanned in, so I'd keep a scanned copy online and just another copy. So, you know, and whatever attorney somebody might use might already have a copy in their files too.
Okay.
But
now we have a few minutes left now on a probate.
Probate. So the probate is always somebody who never did a trust. Okay. So someone comes in, and what happens is the deceased didn't have a will, or they have a will. Okay, but they've never done a trust. So the client comes in, and the problem I see is these clients are coming in and saying, look, my father, my mom, or whatever had property, and now we want to sell it, but we have no rights. There's nothing that says we have any interest or control. Our dad's on title, or our mom's on title, or the bank, the bank has my father on the loan, so we don't have any control over this asset. But it's just been sitting there in probate for like ever, you know. So they need to get some control to sell this property. So they come in, and what they come in to do is something called letters of administration. So it's called letters, like literally letters. So they come in, and we file a notice of probate. We publish it. Everybody who may have an interest gets notified. Okay, and this person, who could be the daughter, could be the son, comes to try to take control and manage this estate. Okay. Now again, the problem is, like I said, is the first thing you do is go to court. There's court involvement. It's a long process, and a lot of the people who come into probate, they don't pay anything up front to the attorney. So there's no money up front, but the attorney does get paid from the estate. Okay, so so it's and the sliding scale for attorney's fees is based on gross value of the estate, and you can imagine being Silicon Valley what that's going to be. It's pretty high.
Now, in the minute left here, in the probate, you could have siblings fighting over the administration.
You could have siblings fighting on who wants to be the main party to control the assets.
So they get attorneys, and then the probate judge will decide.
Probate judge will decide, and then you can have creditors fighting. You could have people saying, hey, you know what? That person's deceased, but they owe me some money. So there's a deadline for that creditor to file a claim. You know, for example, I have in one case, I have somebody who had a contract with the deceased regarding the property. And when the person died, the deceased's kids were like, no, you're not getting anything. So the creditor comes to me and says, hey, here's the contract. I said, did you file a claim? It's called a claim, is saying, hey, you owe me money. Did you file that claim? Nope. How many days you got left? 1 week? Let's file the claim. So they got to file a claim. It's probate is basically a round circle of assets. And everybody, the creditors, the IRS, everybody's got to take a piece of it.
And that's where the probate judge really earns his pay or
Well,
her pay?
he earns his pay from the beginning because there's a lot more involvement, and
Sure.
and the family matters involved. There's so many issues that come up with the judge. They got to deal with a lot in probate court. So
Okay. Vinod, thanks again for coming out.
you're very welcome.
Can
Been
you
a
stick
pleasure.
around for a recap?
You sure can.
Okay. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We'll see you next week.